Hello members, welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. Today, we are diving back into criminal law or criminal liability, and we shall be looking at the defense of provocation. So, without further indulgence, I'm councilman, and let's jump right in. It is a partial defense to the offence of murder, which reduces the offence from murder to manslaughter. Here it is when the accused has killed unlawfully another person under heat of passion. It originates from the English common law and is codified under the Ugandan law in the Penal Code Act Cap 128 under section 193. It was seen in the case of Uganda versus Ijo. This is criminal section number 76 of 2017, where the deceased suddenly punched the accused at the back of the head. The court found that it was sufficient to claim provocation since it was of sufficient gravity to put the accused under heat of passion and cause him to lose self-control and cause subsequently the death of the deceased. In essence, provocation has been defined according to the Merriam-Webster dictionary as such conduct or action on the part of one person towards the other which tends to arouse rage, fury, or resentment in the latter against the former. Well, after looking at a general overview and a formal definition of provocation, now we are going to dive into the elements of provocation, and we shall look at what are the elements of provocation, where are they provided for, and how are they adduced in court of law, and what is the effects of these elements once proved. The first element, as provided for under section 193 of the Penal Code Act Cap 128, as we shall see it after reading the statute, we shall look at the provocative act or conduct. This is an act posed by someone, done by someone towards another that pushes the other to have that explosive anger, that explosive heat of passion, and that pushes him. So there is first of all an act or conduct that is provocative in nature. Secondly, we shall look at the victim or subject of the provocation. Here we are looking at who is to be provoked, for someone to claim provocation after committing an homicide. So here we shall look at an ordinary person first of all, someone who is provoked and reacts, sufficiently provoked and reacts to that action as a result of explosive anger can claim provocation. But someone can also claim provocation if the provocative act or conduct is done against a person who is under his immediate care or control. Here we are looking at maybe people under one's custody or parentage in instances of custodianship. We are looking at who is to be the victim or subject of the provocation. In a third position, we are looking at conjugal relationship, we are looking at parental relationship, we are looking at filial relationships. So once people are spouses, parents and children, we look at even the master-servant relationship. So once you can claim provocation if the provocative act or conduct was done against that person. So that being the second element of the defense of provocation. Thirdly, we are looking at the gravity of the provocative act. So here the court does not look at the fact that at objectivity, let's say, that this act is deemed to be enough to cause provocation, but the court will look at that particular instance. In that particular instance, did you lose self-control? Was it in that particular circumstance, was it enough to put you under that heat of passion? So that is how the court shall determine gravity of the provocative act. So now we shall look at the heat of passion. Here, after that act, the reaction to the other subject is that he loses self-control in heat of passion. There is explosive anger in him that arises as a result of that action, as a result of that provocative action or conduct done towards him, people under his care, to his parents, children, and so on, as we have cited. Then we are looking at the lack of premeditation. Here, you won't claim provocation if there is sufficient proof that this act or that committed homicide was premeditated. So, what is the most relevant here is the fact that it is under that heat of passion, that immediate action causing you to react and commit an homicide. And lastly, we have no time of cooling of that heat of passion. So here we are looking at the fact that the accused, after being provoked, does not have time to cool for him to inflict the act or to inflict the act that will cause homicide of the deceased. So once there is time to cool, maybe in an instance where after being provoked you start running after the person, maybe for 2 hours, then you leave him, then now tomorrow you come and you want to kill the person and say that you were provoked. That will amount to murder because there is premeditation and there is already time of cooling. So there has not to be time of cooling. And after looking at the elements, we are now going to be looking at what does not amount to provocation. What are these instances that we may think that would amount to provocation, but in actual sense, they do not amount to provocation. Here we are looking at the first fact that under subsection 3 of section 193, providing for provocation defined, we are looking at a lawful arrest. A lawful act does not amount to provocation. Here we are looking at instances where we have lawful arrest. For example, a policeman who is having a warrant, a police officer who is having a warrant to come and arrest someone, you won't say that you were provoked, that's why you killed the person. So a lawful act does not amount to provocation. Once there is legality in it, it cannot amount to a provocative act. Secondly, under subsection 4, we have the fact that incitement does not amount to provocation. Someone who is inciting another person, let's say two friends are a friend of A being a friend of B. A comes and tells B that, you know what, so and so is saying this about you, so and so did this, and then it incites you to go and commit an homicide afterwards. That one cannot amount to homicide, even if it's the truth. Whatever was being said was the truth, or whatever conduct that was inciting was the truth, it would not amount to provocation. And lastly, we shall look at the fact that an unlawful arrest under subsection 5, an unlawful arrest will only amount to provocation if at the time of the arrest, be careful members, if at the time of the arrest the accused is aware of the illegality of the arrest. For example, police officer come and want to arrest you, but at the time of the arrest, you do not know that maybe they do not have a warrant or a search warrant to come and search your house. And for example, you decide to defend yourself and you end up killing, you end up committing homicide. So this would not amount to provocation if at the time of of that arrest, you did not know that it was not legal. But if you knew that it was not legal and you decided to defend yourself, and you ended up under that heat of passion killing someone, it would amount to provocation. And well, after looking at what does not amount to provocation, now we are going to look at the tests of determining provocation. And we have two major tests. We have the objective tests, that is the reasonable man tests, and the subjective tests, that is the particular test, in which we look at the given circumstances of the occurrence of the provocation alleged. And here we are looking at, first of all, the objective test. This is the test of a reasonable man. The court will inquire whether, in the same circumstances, would a reasonable man also fall under loss of self-control and commit the same homicide. And if the court finds it sufficient that it was the gravity of the provocative act was enough to push the accused to lose self-control, the court will, of course, consider it. And otherwise, the court would not. And secondly, we look at the subjective test. This is looking at the particular circumstances and inquiring whether that particular act did put the accused under heat of passion. And once the court is satisfied with that, it can also consider it, or otherwise not. Well, after looking at that, we shall now look at what can disprove provocation and the effects of provocation, legally speaking. First of all, what can disprove effect? We have three major points, but there can also be others. I urge you to go for further research. But what can disprove provocation? We have intoxication. Once we can prove intoxication, that the accused was intoxicated at the time of committing the homicide, the provocation will not stand. Secondly, we have malice. Once we can prove that there was malice in what he did, maybe they had anger issues in the past, and he just took advantage of that moment to commit the homicide, the provocation would not stand. And lastly, we have time. If there is time of cooling of the heat of passion in that particular circumstance, provocation would not stand. Lastly, we shall look at the effect of provocation. And obviously, as I earlier said, provocation will have as effect a mitigating effect to the offense of murder, rendering it the homicide of manslaughter. And that said, the punishment as prescribed in the Penal Code Act is life imprisonment. Well, thank you for watching this video, members. We urge you to support this initiative, Agora Legis, by liking our videos, subscribing to the channel. Do not watch for free. The only way we can uphold this idea and this vision is to subscribe, like, and share. And thank you for watching. It was Agora Legis with Council Ben.